So just to introduce Daniel, he's an author and journalist who's published extensively on refugees, migration, asylum seekers in Britain and Europe. His full biography is in the description of the series. But just a few highlights to emphasize. His first book was Bloody Nasty People, The Rise of Britain's Far Right, published by Verso in 2012. And then more directly relevant to this series is Lights in the Distance, Exile and Refuge at the Borders of Europe. I read it myself over the weekend, and I strongly recommend it. And I'm going to just actually read a couple of short passages from it just to give you a flavor, but also because I think they introduce the concerns of the series really well. Daniel's also a frequent contributor to the London Review of Books. He often writes the long reads in The Guardian. He's written for the New York Times, the TLS, Prospect, and the New Statesman. But I wanted to just, as I say, just to before letting Daniel take over and start talking, I wanted to just read you a couple of passages from the book, which I thought were really striking, and as I say, set up the debates we're interested in very well. The one is a passage about 3/4 of the way through the book where Daniel meets Hakimo, who's an Afghan refugee in Athens in 2012, and Hakima says to Daniel, we keep having journalists visit us and they want our stories, but tell me, what can you do? Nothing changes. And it's a really challenging question that every refugee, every migrant could pose to a journalist, but also to an academic, to anybody who's a scholar, who's in a relatively privileged position, who's wrestling with these things. And I thought Daniel's answer, which he writes here, is provisional, but it's a helpful starting point. He says, often journalists like to think that what they're doing is going to provoke a change. It's really the case, at least not in any direct way. Instead, if there's anything useful in our work, and as I say, speaking about journalists, but I think he could be speaking for all of us who are interested in these issues, it's more like fitting the pieces of a shattered mirror back together to explain how a person or a community has come to find itself at an impasse. As writers, we have the luxury of distance. We can step back from a situation, try to untangle a web of cause and effect that surrounds it, and retell it in a way that makes sense. So I think that, as I say, that's a kind of provisional answer is how we respond to that very difficult question, which a refugee or an asylum seeker might pose to those of us who are well-intentioned, want to understand, want to engage with migration, with resisting the hostile environment. And then I wanted to just read the final paragraph from Daniel's book, which asks, it doesn't end on a proposal, it rather ends on some uncomfortable questions, the kinds of questions I think we will return to over and again. It reads, the refugee needs to get to Europe to earn a living. Why can't refugees earn a living at home? Why is Europe a place where one can earn a living? How does the place they come from relate to the place they're headed to? Why should anyone have to put up with these conditions? And this, I thought, was a particularly crucial question. What set of interests does it serve to regulate the movement of migrants? And how likely is it that states which treat migrants so badly are going to treat their own citizens? And that's again a really difficult question. So with those questions in echoing in our minds, I'm going to hand over to Daniel and ask him to talk to us, let's say, for roughly 20 minutes. And then as he talks, you can type in questions, and then Dan will ask the first question, and then we'll open it up to everybody. So over to you, Daniel.
Right, thanks very much, David. And thanks, David and colleagues, for inviting me to speak to you. So I'm going to draw on some things from my work, my journalism that I've done on the UK specifically, in general, but with a particular focus on the bit of work that's occupied my mind the most over the last few months, which is some work that I did on the UK-Rwanda asylum deal, which, as I'm sure you know if you've been following the news, is making its way through the courts. There's a legal challenge to the policy that reached the Supreme Court last month, and in fact we just heard that the judgment from the Supreme Court is going to be handed down next week. So I think this is a good time to be talking about these things. And I've been thinking about the work I did on that and thinking about what are some wider points I can draw from that. that would be useful to talk to you about today. And I was also mindful of the fact that, given that this is a politics, language and literature research group, I've tried to just add in a few thoughts on the role that I think language plays in the subject that I write about. So I've been writing about immigration and asylum for more than 10 years now. And one of the things that I find myself doing quite often is trying to work out the balance between where's the continuity in this situation and what's different about what's happening now. And for really, I think this is really important for such a politically contested subject as this, that often I feel what I'm doing, in fact, over the last few years, as migration has become increasingly politicized, particularly around refugees and asylum, and as sort of right-wing populist discourse has increasingly become mainstream, I think there's been there's been a lot of alarm about what results from that. And a lot of the work that I've done has been focused on saying, well, actually, look, we're all worried about what Trump is saying or doing now, or what Boris Johnson's Tories are saying or doing now. But actually, if you look at the background to this, there's a lot of continuity with what was happening before. A really crude example of which is, when Trump was US president, people were very worried about the the detention and deportation regime in the US. And then people who'd been following the issue for longer kept having to point out, well, actually deportations reached record levels under Obama, and a lot of the infrastructure that Trump is using to enact his policies was built by the Obama administrations or the Bush administration before that. And I think the UK Rwanda policy, the asylum deal by which Rwanda has agreed to take asylum seekers from the UK and deal with their asylum claims there, is a really good sort of case study in thinking about, well, what are the kind of longer term processes at work in this area of immigration policy, and what's kind of new and different about this moment we're in. So some very, very broad background, first of all, just to kind of set the context. I'm going to spend most of this, almost the entire time we have here, talking about a really specific area of migration to the UK, which is asylum, people seeking refuge in the UK, and also then how the state deals with migrants that it doesn't think should be here. So that might be refused asylum seekers, or it might be other people who the British state has decided need to leave the country or need to be forcibly removed. But obviously that sits in a much wider context where Britain, like every other state in the West, has overall pretty liberal immigration policies. There's a very good new book out published by the Dutch migration scholar Hein de Haas, which argues quite persuasively, I think, that since the Second World War, seen as a whole, the West's migration policies have tended towards becoming more liberal, more open, that this has been relatively consistent across governments of the left and the right. But the trade-off of that is, because there's always the need to make a certain section of voters feel like migration is being controlled or even reduced, there's a real overemphasis on, he calls it bold acts of political showmanship, but very ostentatiously tough policies aimed at what politicians will normally describe as illegal immigration. And that's really been the case for the UK, certainly for the last 20 or 30 years, where, in general, migration policies have been relatively open and liberal, but there's been this fairly relentless focus on what to do about the so-called bad immigrants. So that might be at different times where the right-wing press has picked different targets. It could be illegal immigration, at the moment it's boat crossings from across the Channel. A few years ago, the focus was actually on foreign national offenders and the ability of the state or not to remove them from the UK. But that's been a fairly constant feature of British politics for the last 20 or 30 years, and it's led to some very, very severe policies as a result. The hostile environment of Theresa May's coinage that David described earlier being one such example. And I think there's two key concepts at work there that are not my own. I've borrowed these from the migration scholar Nicholas de Geneva, and any kind of misinterpretation of his use of them is entirely my fault. I'm a journalist, so I just pick these things up and I'm not particularly rigorous about them. But I think what was very useful to me in reading his work is that he talks about these two concepts of deportability and illegality. And you see these two concepts dominating the way that Britain deals with unwanted forms of migration. So deportability, crudely put, is the set of policies and techniques and structures that the state has to keep certain people in a physical state where the state can very easily pick them up and move them around and remove them from the country if it so wishes. So a really good example of where that's been very heavily at work in recent history in the UK is in immigration detention. The huge expansion of immigration detention in the early 2000s was explicitly done to increase the so-called deportability of asylum seekers. It was done on the basis that, well, Britain has lots of asylum seekers coming, there are lots of asylum seekers coming to the UK. A large number of these people are people whose claims will be refused. So it's the state will have more control and it will be able to carry out its tasks more efficiently if it keeps people in immigration detention rather than letting them live in the community. And at the time that the detention centre network was expanded in the early 2000s, the justification for that was, well, it will be quick and clean and efficient and people will be in and out of there in a matter of days. Obviously, what we then saw happen was very different. And then the other concept, illegality, I think is more obvious what that means. The focus on so-called illegal immigration is a kind of very prominent theme in British politics as it is elsewhere. But I think the key point about it is that again and again, you see how actually, although politicians will be proposing to deal with illegal immigration as they characterize it, as if it's a kind of phenomenon that exists out there in the world, independent of their actions, a huge amount of policy energy is put into making people illegal in one way or another. So the hostile environment policies that were launched by Theresa May in 2012 are a really good example of that. I'm not going to enumerate them now, but I think the most telling one for me was something that was snuck away in one of the, so she passed two acts that brought a lot of hostile environment policies into law, one in 2014, one in 2016, and I forget which of the two acts this was in, but it created a new offence of illegal working. So if you were, or if you are in the UK, you don't have immigration status and you're found to be working on the black market, it's now potentially a criminal offence to do so. Before it, you may well have been stopped from doing it and your employer might have been fined, but you, as the person doing the work, can potentially receive a criminal sentence for having a job. At which point you become an offender if you're convicted, at which point you become a foreign national offender. And as the politicians have told us repeatedly for years and years, foreign national offenders are people that they would like to remove from the UK. So you can see there very clearly how this idea of illegality is something that is not just kind of like out there in the wild, but is produced by the state and produced by policies decided on by the very ministers who say they're there to reduce illegality. And I think those two things, deportability and illegality, also they reinforce one another, both in practical terms, but also rhetorically. So that example I mentioned earlier of Blair era immigration detention, the way that was set up in the early 2000s was it wasn't a punishment for people. People were being detained essentially for their own good, so that the asylum caseworkers could keep them in place and check their claims and process their claims quickly. And then if you were accepted as a refugee, you would be out of the detention centre, given refugee status and allowed to integrate with wider society in the UK. But the whole notion of a detention centre, or somewhere that people are kept forcibly, somewhere that's fortified and guarded and so on, even if it doesn't say it explicitly, that is very obviously the message given by such a building and a structure and a process that people put through is that that's somehow associated with people doing things that are wrong and potentially criminal and illegal. And you can see in the way that the culture of detention centres have developed over the last 20 years, and what they're used for, that the institutional dynamic is very much that they're there to punish people for one thing or another. And so I think that's the kind of constant dynamic that has been there for years and years in British politics, in the way that this end of immigration, sort of asylum, so-called illegal immigration, and so on, are sort of talked about in politics, and also what policies are actually doing. And you can, in one sense, see what's happened in the last couple of years is fitting right into that pattern. So the UK-Rwanda asylum deal and the two associated acts of parliament that go along with it, the Nationality and Borders Act that was passed when Priti Patel was Home Secretary, and the Illegal Migration Act that was passed this year under Suella Braverman, fit into this idea. They fit that pattern of politicians saying they're going to do something about it, what they call illegal immigration, and then enacting policies that actually create or increase the sense of illegality and criminality around it. So, I mean, even the wording of the most recent Illegal Migration Act gives you a clue as to what's going on there. And in what it proposes practically, it proposes quite explicitly to punish people who come to the UK in search of asylum without the UK's permission, and to detain them. So it's all about creating structures and ways of thinking about immigrants of those backgrounds that are very heavily associated with ideas of punishment and criminality and so on. But I think, having said that and having stressed the point of continuity there, I think it's really important at the moment to see what is actually qualitatively different about what the government has been doing in the last few years. I think one way is because the policies that have been put forward in the last couple of years have just been so extreme. They are, again, fairly explicitly aimed at breaking, kind of diverting the UK from existing human rights standards and norms, particularly around refugee protection, and even sort of undermining or potentially breaking the international system that we currently have. So the Rwanda policy, which I'm going to assume you're all pretty familiar with, but the crucial detail of which is not only that the UK is outsourcing its asylum hosting to another country, it's that the policy will send asylum seekers to Rwanda permanently. So unlike other sort of so-called processing arrangements that other countries have explored in the past, or Italy signed a deal with Albania the other day around the processing of asylum seekers, this effectively banishes people from the UK permanently, and is an attack on a fundamental principle of refugee protection, which is the right to territorial asylum. So that's the right to claim asylum in a country that has signed up to the Refugee Convention if you reach its territory. But I think also what's happening now is qualitatively different on the level of political language and discourse as well. And I think a comparison with Theresa May and what she was doing around the hostile environment is a good illustration of what's changed in the last decade. And I think this is a result of something that's very familiar to all of us, but it's the kind of the encroachment of right-wing populist ideas and rhetoric and ways of behaving on to mainstream politics in the UK, as has happened in quite a lot of other countries. But I think previously, governments dealing with asylum and immigration control have tended, in the UK, to kind of position themselves as I suppose they'd see it as a kind of honest broker between different interest groups. So, you know, they would say, well, we encourage immigration, we think it's a good thing in general, but there are these bad categories of migration that certain voters don't like, and therefore we have to be seen to be cracking down on them in order to keep everything going. So, you know, in order to give deserving refugees asylum, we have to crack down on so-called bogus asylum seekers and so on. And the kind of the rhetoric and political positioning around the policies has tended to be framed that way. So even when, say, Theresa May, you know, in rolling out the hostile environment, they used some very extreme language at an early stage, where the Home Office trialed these advertising vans that drove around multi-ethnic areas of London with the words "Go Home" written across them. You know, that was extreme language. It was language that, you know, you could say came from the populist right. But it got a lot of criticism, and very quickly the Home Office and ministers disassociated themselves from that. In the current setup, you know, in the kind of post Boris Johnson government we have, I think the way that ministers have justified policies has been to much more heavily lean into the right-wing populist framing of the issue. So rather than kind of posing as this honest broker kind of trying to balance everything together, certainly Suella Braverman, and I think to an extent Priti Patel as well before her, have just lent into the kind of the attack on refugees, you know, using language like invasion to describe what's happening, and also not only just rhetorically attacking those specific targets. So, you know, when Suella Braverman talks about small boat crossings from France to Britain and describes the phenomenon as an invasion, it's not only picking on a convenient scapegoat, but it's part of a wider set of so-called culture war techniques that use the issue as a sort of wedge to divide people and to sort of pit everybody into these two polarized camps. So, you know, if you look at the rhetoric, the government's rhetoric around the court challenge to the UK Rwanda asylum deal, for instance, it doesn't only stick to saying, well, look, all we're doing here, our policy is a perfectly sensible way to try and deal with a real world problem, and that's what we're doing. What the government says as well is, well, actually, this is just one front in the battle against the, you know, the woke liberal elite, the blob, left-wing activist lawyers. They've got all these different phrases for it that, you know, ministers will use, or their allies in the media will use. So it's this sense that this one issue then becomes just yet another front in this wider sort of cultural political struggle that the government is kind of throwing itself into. So those are a few thoughts on kind of what's similar and what's different at the moment to how things might have unfolded in the past in the UK. I think I wanted to make a final point as well, is that another feature of where we are now, something that has become more prominent politically in the last few years, is that increasingly the law and the courts have become a political battleground as well. And, you know, that's something that has been there since the Brexit referendum, which obviously had this very polarizing effect, which saw people resort to legalistic methods to, first of all, try and overturn Brexit or rein in aspects of Brexit, but then also because the Johnson and Sunak governments have had a deliberate policy of trying to roll back human rights protections and you know, reduce the various ways in which we can hold the state accountable. Challenges to those things have inevitably ended up in the courts because it is about law and legal protections and so on. And the UK Rwanda policy fits really squarely into that as well, I would say. You know, the policy itself has been highly controversial. When it was, you know, there's been all the kind of political debate when it was launched, there've been protests against it and so on. But the kind of central thing over the past 18 months has been the court challenge. And so that's actually where a lot of this has been fought out. And that, you know, just think about language briefly, that sort of adds another area of language into the mix that I think is really important, which is legal language. You know, because obviously court cases, particularly a case of this nature, it's all about the interpretation of laws and any interpretations of what the government has said or published, and how those things relate to one another. And immigration law and the language of immigration law has for a long time been subject to really intense scrutiny. You know, going back years and years, if you think of the amount of media coverage that decisions about deportation of foreign national offenders might receive, of, you know, immigration and asylum tribunal decisions, which, you know, otherwise obscure bits of the courts and tribunal system have for a long time been fodder for, you know, really intense media coverage, both from liberal left and right-wing media, and the particular uses of language within that have been really kind of, I suppose it becomes very volatile, because language that exists in one context, you know, the legal context, becomes very quickly politicized and its meaning argued over and even distorted and changed. I think there's a really good little example of that. I have to credit my partner, who previously worked in immigration law and is now doing a PhD, pointed out, so credit goes to Katie. But it's this term that you very often see in litigation over immigration about, you know, appeals against decisions made on immigration and asylum cases by the Home Office. In the court, in the legal arguments, you'll see arguments over whether the Home Secretary has been irrational. And judges will quite often find, you know, if they find against the Home Office in a particular case, they will find that the Home Secretary has been irrational. Now, in legal terms, in immigration law terms, as far as I understand it, you know, that's actually a fairly dispassionate term, which is about, well, did the Home Office, you know, when it was considering, for example, somebody's asylum appeal, did it go through all the correct procedures in order to consider it? Did it can weigh the evidence properly, and so on? But, you know, a journalist picks that up and reports on it, and it can very quickly become judges call Suella Braverman irrational, and then all the other connotations that word might have come into play. And there's all sorts of ways in which that can happen with court cases when they kind of get drawn into the political arena, as they do. And I think the Rwanda case, which is a big complex case that involves millions and millions of words of documentation, of internal government communications, of policy and research documents, of witness statements, and so on, you can see all of this really at play there. And I think I didn't want to dwell too much on the piece that I wrote about this recently, because if you're interested, you can go and read about it yourselves. But I wrote a piece for The Guardian long read about the progress of the case so far that was published about a month ago. And what I did was trawl through a lot of the evidence submitted in court and argued over in court. And what came out there really strongly to me was the way in which it gives you this really interesting insight into how the state kind of, you know, not only how it kind of makes its policy in practical terms. So there's a lot of discussion about, well, how did Britain go about approaching Rwanda and negotiating, and how practically were they intending to you know, move people from the UK to Kigali, for instance. But also, as comes out in the evidence that has been made public in court, there's this whole process of constructing a sort of, I suppose, a legal, and I mean, this is my take on it, at least, a legal and linguistic facade. You know, the government has been, if you look at the difference between what the government said in public about the Rwanda deal, you know, that this was a great progressive humanitarian thing to be doing for refugees, and what was said in private by some of their own advisors about Rwanda's human rights record and the risk to asylum seekers if they were sent to Rwanda, you can see kind of how the facade was constructed there. But also, because when governments formulate and carry out policy, they have to meet their own laws and their own standards on it. There's a whole series of processes that civil servants have to go through on behalf of their department to show that a policy meets the government's own or the state's own legal standards, and in the Rwanda case, most importantly, that sending asylum seekers to Rwanda is compatible with UK refugee law, other UK human rights protections, particularly under the Human Rights Act and so on. And there was one really revealing area of documentation there that I found in the documents associated with the case, which is that the Home Office has a department called it's called the Country Information Department, and essentially it's a research team that will produce briefings on countries around the world that the Home Office's immigration departments might need to deal with. So if asylum caseworkers need to know about a country that an asylum seeker has come from, they can look at the information collected by the Country Information team. Or crucially for this case, if they're deciding about whether to deport somebody, whether to remove someone from the UK to another destination, the Home Office has produced its own research reports on that, one or other particular country, any issues around safety that are there, and that's supposed to inform Home Office caseworkers when they're deciding, is it appropriate to send person X to country Y, and so on. And to cut a long story short, when the UK signed its deal with Rwanda, they didn't have an up-to-date country information note, as it's called, for Rwanda. So the Country Information team had to go and kind of write one in retrospect. The deal was already underway, and they had to go through the motions of going to Rwanda, going and meeting government officials and other people and asking them, is Rwanda a safe place to send refugees? Writing down the responses in a document that's actually publicly available on the Home Office website. And this has became quite central to the arguments in court, because the government was saying, well, look, here you can see where we've gone and checked everything out, and this is evidence that Rwanda is a safe place to send refugees. People challenging the court case were saying, well, no, because it's ignored lots of crucial information about Rwanda. And then eventually the government was forced to disclose advice from its own Foreign Office consultants, who were saying, well, yeah, this report hasn't actually mentioned the fact that Rwanda persecutes political dissidents, or refugees who speak out are very likely to find their lives threatened, and so on. And it is even quoted by one of the judges in an earlier stage of the case. It was then subject to a quite damning internal review that said this country information note about Rwanda, in this independent expert's opinion, wouldn't even meet basic standards for empirical research, let alone, a crucial document intended to inform policy for a government department. So this is all about the kind of narrative and the language that the government is using to make the policy seem not just politically palatable, but kind of legally sound and bureaucratically sound and the rest of it. And so in a way, that's what this case now hinges on. And I think it's very telling that that's where this has all come down to at the moment, because migration has become so politicized. The processes by which the state regulates and controls migration have become so politicized. And then the mechanisms for accountability and redress through the courts have also become so politicized that the kind of this really crucial fulcrum of British politics at the moment, on which potentially the Home Secretary or even the government could stand or fall, has been condensed into these arguments in court and the arguments over the meaning of words and phrases. And I think the judgment that's due to be issued next week is going to tell us a lot about where that's got to. But one little detail that I'll just finish on that I think summed it up for me is that the main point of appeal in the Supreme Court is to do with whether the British government had sufficiently checked Rwanda out to check it was safe before it launched this asylum deal. And obviously the Home Office says, yes, we did a very good job of checking. People challenging the policy saying no, they didn't, and actually Rwanda isn't safe, so therefore it's not lawful to send asylum seekers there. There's actually there's a few additional grounds of appeal that are a lot more technical and kind of more specific. But one of them essentially comes down to the wording of a few sentences in a bit of post-Brexit legislation passed a couple of years ago. And it's to do with the meaning of etc. in this bit of legislation, because it was the part of the EU withdrawal legislation that the government passed. They passed a law saying, right, well, we are no longer subject to EU immigration rules, and we can now set our own. And the particular wording of this document says, we're no longer subject to these rules on immigration, etc. And now the point of argument before the Supreme Court on this ground of appeal is whether etc. means and asylum. So does immigration as a term cover the asylum system, which in common sense terms is a form of immigration, but in bureaucratic and legal terms it's actually quite separate from other bits of the immigration system? And so this hugely significant, very, very politicized issue is now sort of hanging on these questions of language in this way, which we will find out more about next week. So I think I'll stop there, and if people have got questions, I'll be very happy to answer them.